Adriatic Land 5 Limited and the long leaseholders at Hippersley.
Ms. Hales. Morning, my lords. I appear together with Mr. Birdley and Miss Green for the appellants. My learned friends, Mr. Loveday and Mr. Rowan, appear for the respondent leaseholders. And my learned friend, Sir James EDKC, together with Mr. Walsh, Mr. Chorfey, Mr. Pobjoy, Mr. Perry and Mr. Miller, appear for the Secretary of State. May I just check we all have the same document?
Yes.
You should have, and I'm sure you do, a core bundle running to 255 pages, a supplemental bundle. There's an additional bundle which contains the witness evidence, principally relating to the A1P1 ground. We then have a core authorities bundle. That's common to both this appeal and to the triathlon appeal that, of course, follows. And then with this appeal, there is then a Hippersley specific authorities bundle, if I can put it that way, which probably runs, if you're in hard copy, to a number of volumes.
Yes.
I think some of us are working electronically and some are working in hard copy, but I'll do my best to direct you to the appropriate place.
Speaking for myself, I'm in hard copy, but
yes.
Obviously others electronically.
Yes. I think in addition, you should have a printed copy of Section 18 of the Landlord and Tenant Act 1985 that was handed up this morning.
I see, yes.
I'll come to that later, but that was unfortunately omitted. So I'll return to that. And we've also handed up copies of paragraphs 9 and 10, simply for ease of access, because this is one of those cases where we're going to spend a lot of time staring at the words used in the Act. And we thought it might be helpful just to have that separately. I think I'm right in saying there's some additional authorities the Secretary of State is hoping to rely on. Perhaps we can deal with those in due course, because yes. I haven't seen them yet, but I'm sure there's copies here. There's an agreed timetable for the progression of this appeal over the 2 days. There's some wriggle room tomorrow afternoon. Hopefully we won't need it, but I think we're all comfortable that we should fit within the time allotted.
So much the better.
Just a final bit of housekeeping. There was, of course, or there is a cross appeal in the case for which permission has been granted. So just a reminder that's sort of effectively been parked by consent and with the agreement of the court.
Yeah.
This is, of course, the first time the Act, the Building Safety Act 2022, has been considered, save to a limited extent. There was a case, URS and BDW, which considers the retrospective effect of Section 135 as one of its issues. Just to flag up, a further appeal was heard in that case by the Supreme Court across, I think, 3 days, possibly 4, in December 2024. As far as I'm aware, there's no news on when that decision will come out. I don't think it's anticipated it will necessarily affect the issues in this case, but we can't say there was retrospectivity as an issue. Hippersley Point was also the first time the Upper Tribunal had considered the Building Safety Act. Since then, it has considered it several further times, but not in the context of paragraph 9 specifically. The dispute between the parties here is actually, I mean, it raises very important points of principle, but it's actually relatively narrow in scope. There's no dispute in these proceedings as to the prospective effect of the leaseholder protections in Schedule 8. From the date the Act came into force, in general terms, landlords and managers cannot pass on the costs of remediation to leaseholders by way of a service charge, other than in the ways the Act says they can. The principal distinction being whether a leaseholder holds what's called a qualifying lease. And that means any irrecoverable costs will be borne by the landlords or the managers. And when I refer to managers, I mean if we have a tripartite lease, the named manager. And that will be subject to their ability to then recoup those costs from a third party, warranty provider, the developer, or by way of grant funding. The question is, how does the Act apply to those costs that the landlords and managers have incurred in the years prior to the Act that were not in fact paid by the leaseholders by the 28th of June 2022, the date the Act came into force? And our focus is upon paragraph 9. But of course, the answer in that context will also apply to most of the other paragraphs in Schedule 8. They mostly use the same formulation of words, and they're governed by the words in paragraph 10. So by way of reminder, paragraphs 2 to 4 of Schedule 8 also, paragraph 10 also applies to them, and also paragraph 8, as well as paragraph 9. So the central point really is that point of fairness, the extent to which it has retrospective effect. If I can take you to the Hippersley Authorities bundle, it's tab 67 I'm looking at, which will be right towards the end if you have multiple volumes. I'm just looking at the top of page 2369.
269.
2369. It's just those top two paragraphs there. The question of the fundamental injustice as a general rule of retrospective legislation has exercised the minds of lawyers and parliamentarians for centuries. Now, the Upper Tribunal took the view that the provisions in this case were not in fact retrospective at all. We say that was wrong. And the wider importance of that point when we think about the effect, because, you know, let's be clear, the costs that we're concerned with in this case, the costs of the original dispensation application as the origin of this appeal are modest, less than £30,000. It's the wider ramifications that explains why you have this sea of people before you today. And that wider importance is really brought to life by the witness statements filed by the parties in respect of the A1P1 point. Tens of millions of pounds at stake as a minimum, we say, and across the industry, I'm sure that can't be controversial. However one divvies it up, it's probably more. And the ultimate beneficiaries of the appellant's investments include, of course, pensioners. So there's lots of parties involved here. There's no dispute leaseholders should be protected from their costs as a point of principle. That's because they're not responsible for the defects. And the appellant's not responsible for the defects either. That's the central point. Just by way of brief reminder, the grounds of appeal are in the core bundle, page 16. And I'm sure you've probably seen them. There's only two.
Yeah.
The first being a more discrete one that the tribunal heard in concluding that the costs of a dispensation application fall within the scope of paragraph 9 at all. It's the second one that really engages the wider issues and the greater value, if I can put it that way. The question of what costs does paragraph 9 prevent a landlord from recovering? Does it include the costs that it had already incurred before the Act came into force? Does it apply only to costs that have been rendered payable because there's a valid demand? And then as a subset of that, if you're not with us on our contention that you can't read it in that way and that it only applies to costs incurred prospectively, then we then turn to the effect of Section 3 of the Human Rights Act and the A1P1 arguments that compel you to read paragraph 9 in that way. Because the first of those grounds is something of a more niche point and the other is of wider importance and probably trickier to answer, I propose to spend more time on ground 2 and less time on ground 1. I'm going to take ground 1 at the end of my submissions. So in terms of order of play, really what I propose to do is, other than a brief introduction to the core facts, to the extent that's going to be helpful, I want to introduce the scheme of the Act. then want to say something about the explanatory notes. Then focus in on the words used in paragraphs 9 and 10 and how they should be read. So that's in the context of ground 2. I'm then going to focus on retrospectivity. And then finally I'm going to come to ground 1. And then I'll hand over to Mr Birdling, hopefully before lunch, to deal with the A1, E1 side of things. Well, also, the starting point in any property case should be the building and the parties. This is, unfortunately, despite all the documents in front of you, there isn't a photograph of the building, which is always what us property lawyers like to see, but it is a detached, I think I'm right in saying, block, 32 flats. It's over 18 metres in height. It has issues with the cladding to the exterior of the building. There's a commercial property on the ground floor. I think I'm right in saying it's a library. Issues are discovered with the building. Following some investigations in 2020, turns out some works are required. Various investigations undertaken, a fire alarm needs to be fitted, so on and so forth. And these proceedings are brought. It's an application for dispensation, and we'll turn to the words in section 20ZA in a moment. And this case was never, as you know, about the Building Safety Act at all. This appeal has taken an unusual course. We have the decision of the FDP. It's the decision granting permission to appeal. The Deputy President first raised the point. If you need the reference, it's at tab 12 in the core bundle, but that's where he says, well, actually, and it was a quirk of timing, the Act had come into force 2 days prior to the Tribunal reviewed its decision. So it's an unusual course, but here we are. Can I take it that you've all had the opportunity to read the Upper Tribunal's decision?
Yes.
In that case, I'll take some specific paragraphs in due course, but I won't take you through that now. We know what the President concluded, and really we say that leads to this fundamental unfairness. If I can just take you to paragraph 49 in my skeleton argument, it's page 32 in the core bundle. I say that illustrates the core central point of the obvious unfairness a retrospective approach brings about. When we think about the consequences of a landlord, and this is a landlord that's done this, a landlord that has carried out remediation to one of its properties and holds off from recovering those costs, for example, whilst it's trying to pursue third parties, or protects its ability to recover the costs via a Section 20B notice, or however it does it.
Say you've got a landlord who's not a developer. Could the landlord in a situation like that make an application for a Section 124 order against the developer?
If the developer still exists, yes. The difficulty, so yes, and that is happening, as you see in the triathlon appeal. That does happen. But not every developer is still around.
The retrospectivity point in that case, of course.
Yes, yes.
So it might be right to look at these as interlocking provisions.
They are all part of the same overall statutory scheme, without doubt. And there is, and I'll come on to it in due course, there is some overlap in that the way you decide triathlon will also interact with how you decide this, because there may be, I would say, no need for paragraph 9 to have retrospective effect if under a remediation contribution order application, the Section 124, you could recover the costs where it's just and equitable anyway. That would be a solution where the whole statutory scheme fits together. I'll come to that in a moment. But, my Lord, you're right. There may be a remedy against the developer, but we have to remember a relevant defect goes back 30 years from when the Act, I think it's from the 14th of February, in fact, from the reset date. Just sticking with the purpose of the Act, we all know the origin, why we're here, and I don't think the broad legislative purposes behind the Act are in dispute either. They will be common ground. There's probably four core purposes so far as relevant to Part 5. Ensuring unsafe buildings were remediated, protecting leaseholders from the costs associated with remediating historic building defects, trying to ensure those that were responsible for the defects are held liable, and restoring stability to the lending market. It's probably irrelevant for current purposes, but it appears that that was the government's subjective intent as well. Mr Murphy's witness statement for paragraph 146 sets out what he says was the government's subjective intent.
Sorry, which paragraph did you say?
Paragraph 146.
Yep.
If you want the reference, it's the additional bundle, tab 4, page 131.
There will be questions about the admissibility of everything Mr Murphy says when we're simply looking at a question of statutory construction. We don't normally.
Well, I would say it's completely inadmissible in that, and I would say that can't be controversial, but I'll wait to hear what's said about
Even
it.
on the A1P1 points?
Not on the A1P1 points, I defer to the public lawyers, but as a matter of orthodox construction, I say it's simply inadmissible. And I'll wait to see how the Secretary of State puts her case. But, yeah.
Thank you.
I want to say something about the legislative timetable, because that's relevant to the background to the Act and the scheme. The bill was first introduced on the 5th of July 2021. At that point, almost none of what is Part 5 existed at all.
Introduced in the Commons.
Yeah.
Sorry, that was the 5th of
July 2021.
Sorry, thank you.
There were one or two provisions that concerned service charge recovery, principally a duty upon a landlord to pursue third-party recovery, to take reasonable steps to pursue third parties and grant funding, or have its ability to recover service charge limited. But that was it. We then come to January 2022.
Sorry, which provision was that? Or is it in the final Act?
Not in the same place in the same form, no.
Okay.
No. Part 5 looks for the purpose of what we're looking at, completely different.
Yes, but the provision you just mentioned, was that to do with building defects, or was it wider?
It was a limit upon the ability of a landlord to recover by way of service charge the cost of remediating buildings,
Okay.
or where then it had the ability to pursue third parties. So if a landlord says, I want £1,000 from every leaseholder for fixing X, and in fact the landlord could have claimed under a warranty to get X, or could have reasonably pursued a developer, the idea was that the landlord would be under an obligation to do that, or the tribunal might reduce the amount that can be recovered.
But it might be helpful in due course just to know where that ended up, if it's still there. Not now.
Yeah, we'll look into that. We come to January 2022. Secretary of State, Mr Gove, announced a series of amendments would be tabled. It was on the 14th of February 2022 that the origin of what is now Schedule 8 and most of Part 5 was introduced. It was after the third reading in the House of Commons. The respondent, it's attached to their skeleton argument, but it can also be found as the very last page in the Hippersley Authorities bundle, has summarised the relevant parliamentary materials. So one can see, I'll perhaps take you to them in a moment. You can see the level of discussion and explanatory notes that followed through with those amendments. They're very limited, in short. And the Act received royal assent on the 28th of April 2022, as you know, with Section 122 and Schedule 8 coming into force 2 months later. The broad point is 14th of February 22 is the first time anyone sees the provisions. By that point, we've already had the third reading in the House of Commons. There was very limited available time for scrutiny of the bill. It was rushed through. I put that neutrally, but it was as a matter of chronology, it was rushed through. Most of the provisions in Schedule 8 are reliant upon secondary legislation to form a complete coherent scheme. We don't need to look at the secondary legislation for the purpose of this appeal, but Schedule 8 doesn't work without that secondary legislation. That didn't even exist at the point when Schedule 8 came into force on the 28th of June 2022. So it was an incomplete scheme when it came into force. There was no way of working out what to do about landlord certificates and leaseholder deeds of certificates, calculating property values for the purpose of understanding how the caps work. None of that existed. In one instance, not even in draft form. So that, again, illustrates how quickly this legislation was brought into force. And even that secondary legislation has had to be amended several times since. Now, the respondents make a point in their skeleton argument. It's paragraph 31, sub 3. It's page 70 in the core bundle.
Sorry, could you give me the page again?
It's page 70, my lords.
Thank you very much.
Core bundle.
Sorry.
I'm looking at the third line down in subparagraph 3, where they say the emerging provisions of the Building Safety Bill would have been known throughout the dispensation litigation. That can't be right. The final hearing in this case was December 2021, and the provisions were announced on the 14th of February 2022. It's probably irrelevant, but I just want to make the point, none of this was foreseen, could have been foreseen when the principal costs were incurred on the litigation. And that's confirmed in Mr Anderson's witness statement for the avoidance of doubt. Well, I get the impression that I don't need to take you through Part 5 and Schedule 8 in broad terms, and that you've had a chance to look at that. So I don't propose to explain how all the different definitions and how it fits together. Can I turn to the explanatory notes?
Yes.
Because it's quite important to understand the status of the explanatory notes. The Upper Tribunal's decision isn't expressly based on what they say, but certainly a degree of emphasis was placed on them. And that's a common feature of most of the cases that have looked at the Building Safety Act to date. And it's perfectly understandable. And indeed, in this case, I think I referred the President to the explanatory notes. I was instructed relatively late in the day, but nonetheless, I'm confident I did, and indeed the President conducted his own research into the explanatory notes later on and came back to the parties on that. The difficulty is, on closer inspection, there's some danger in doing that. And we address that in our skeleton argument, paragraph 60 to 66. It's core bundle page 37, if you're looking at that. The first point we make there, which is at paragraph 61, is that the extracts from the explanatory notes relating to paragraph 9 and to section 122 are not within the category of explanatory notes prepared under the authority of Parliament that are capable of casting light on the meaning of particular statutory provisions. And that's by reference to Owen, Secretary of State to the Home Department. The key point is, have they been prepared under the authority of Parliament? Well, if they weren't before Parliament, how can they have been? The explanatory notes were not endorsed by Parliament. They weren't before them in any recognisable form, so far as they relate to Part 5 and Schedule 8. This point isn't good for other parts of the Building Safety Act, where of course there were detailed explanatory notes brought in with the bill in the usual way. And yes, there may have been some tweaks along the way, but broadly there were explanatory notes that carried through to the end. That just simply isn't the case for Part 5. And that's of course why often we can refer to these explanatory notes, because they were introduced with the bill. People had reference to them during the debate, everyone understood the position. The top of page 30, just going over a page in the core bundle, at the top of
And in
page
due
30.
course, you'll take us to those notes, both in the form that I think came before the House of Lords and the ultimate form.
I don't think the form that came before the House of Lords is actually in the bundle, but we can find a copy of it. But it really just, there's nothing there because the provisions didn't exist.
Somewhere.
Yeah, I don't think it is.
You don't think so?
There is the what we do have is there is a short explanatory note which I'll take you to in a moment.
Yes, I see.
That came in with the amendment.
That's what I had in mind.
Yes, I'll take you to that. Yeah.
Yeah.
In fact, I think it's cited at, if you turn to page 38, subparagraph 3.
Yes, I see.
It's there. Let's start 74. The italicized.
You took us a moment ago to your authorities, Bundle Volume 6, page 2399, the summary of parliamentary materials.
Yes.
I think it's in there, isn't it?
I think it's there as well. Yes. 2369.
Yeah.
Those two passages that you see on.
If I look at all these different spaces, 2405 is, I think, the original document, or 2404 on this.
Yes. Lord, yes.
Yeah.
Now, just looking at those two passages, they really are silent as to the position of costs that have already been incurred. They certainly don't highlight a degree of, in my submission, of retrospectivity. The explanatory notes published post the Act, which you do have the relevant extracts of in the bundle, what they're doing, therefore, is stating the executive's view on something that's really a matter for you to determine. I don't say they're inadmissible, I accept they're technically admissible, but I say no real weight can be attached to them, so far as the matters in this appeal are concerned. And they don't express any reasoning to substantiate what's said in there. The assertion that Schedule 8 has retrospective effects, the reasoning for that is simply left out.
Can I just pause a moment? I can't remember where we find the explanatory notes, but they duly say at the top they're not endorsed by Parliament or whatever it is. Is that in the core authority?
Yes, I think it is. It's at the end of the core bundle. And I think you're thinking of page 375 of the core authority bundle.
So they don't form part of the Act and haven't been endorsed by Parliament. But you were explaining a moment ago, to a great extent, what we have here does reflect what was available as the legislation went through Parliament. Not in these particular respects, but if you look at the explanatory notes generally.
Yes, I think I haven't done a direct comparison, but for example, parts 3 and 4 were introduced when the bill came in. They did change a lot through the course of debate, but substantively there were explanatory notes that related to those core provisions. It's probably for people in another case to debate the extent to which they changed, but certainly there were comprehensive explanatory notes relating to the original bill, but none of that relates to what we are looking at.
And I understand that. Just to understand how far you go, I mean, they do state in the top bullet point on page 375,
yeah,
they do not form part of the Act and have not been endorsed by Parliament. Now, you were saying a moment ago, well, the things that courts can attach importance to are endorsed by Parliament.
yeah.
And that would suggest that you can't attach any importance to any of this, but you don't go that far.
I don't say they're inadmissible. But to give an example, sometimes government will publish guidance notes after an act has been brought in as to how they say local authorities might interpret the act and might want to. One could look at those guidance notes. I think we've got the relevant extracts from Benyon where it deals with this. You could look at them, but the weight that you might afford to them depends on the cogency of the reasoning expressed within them. These explanatory notes don't contain any reasoning. They boldly assert that it has retrospective effect, but don't explain on what basis. There's no reasoning. So except they're admissible, technically admissible, I just say you can't attach any weight to them. The only real reference to retrospection during the passage of the bill, so far as Schedule 8 is concerned, you can see in an extract from Hansard. I think we have it at paragraph 64 in the skeleton argument, but I dare say it's also at page 2369. Sorry, not 2369. 2399.
Yes.
And in fact, it's over the page at 2400. Been helpfully reminded the original of what we're looking for is at 2407. My apologies, a couple of pages over. The extract from the Hansard.
Yeah.
And you're looking at, you can see the sidelined paragraph there in the middle of the page.
And that's dealing with a different aspect.
Well, the reference, yes, the reference to the cap is the reference to what is paragraph 5 of Schedule 8.
5 and 6?
Yeah.
Of Schedule 8?
Yeah. And really, that's it's retrospective in the sense it's a look back and saying, well, if you spent more than this in the past, in the future, you won't pay any more. Even then, it's sort of a high. It's not completely retrospective as such. So what's being said here is retrospectivity does kick in to that extent, and even that, in my submission, is not. We could debate the extent to which it's retrospective. It's a look back. If you spent more than this prior to the act, then for the future you won't have to pay more. And they accept we're not going back to refund people.
If you apply that to a cap of £1,000, and if you've spent £1,000 in the past, you don't pay any more. If you haven't spent £1,000 in the past, then you can be liable for £1,000.
Yep.
It's irrelevant for that exercise whether the service charge has been demanded or not. If it had been demanded, landlord might have demanded £10,000 from each leaseholder, and some of them might have paid. They've paid the 10,000, and then they don't pay any more because they've paid more than 1,000. Some of them might not have paid, and the ones who haven't paid, They don't have to pay 10,000, which is what the others pay. They only have to pay 1,000. So that's how that works,
Well,
isn't it? Or maybe
at a helicopter level, yes, but it suffers from the same difficulty of paragraph 9, which is service charge provisions are complicated. They're simple to explain, but when you actually come to it, because you've charged sums on account, so say you've charged sums at the start of the year by way of a budget, and included in your budget was a certain amount towards anticipated remediation costs. But it's all broad brush. So you might have charged sums on account for a year that falls in the middle of when the Act comes into force. How does it work is a matter for another case.
I understand that. But the general idea that from the reset date, 14th of February, anything you've paid already, well, that's past history. We're not going to reopen it, but we can look back at what you've paid. And some people who have paid promptly end up paying more than some people who've paid nothing. Because what you're doing is you're capping it going forwards, having regard to what you've already paid in the past. That's the general message that the minister's giving you.
I think I have to accept that's right. That doesn't mean they've thought through how, in fact, the mechanism works as a matter of law. But I think I have to accept that's right, yes.
Now, if you substitute for the cap of whatever it is, which depends on the value of your property and whether it's a month, an element where the cap is 0, then why can't you say the same? Say, well, some people may have paid in the past, and that's fine. We're not going to ask the landlord to pay that back, but some people may have had demands and not paid. But for them, it's 0. They don't have to pay anything going forward, whether or not it's being demanded.
I think there's two things here. One is paragraph 5 doesn't operate by reference to paragraph 10, which specifically focuses in on the word costs incurred. That's the principal distinction. The second point is the way, in fact, how paragraph 5 works isn't completely clear. I understand the intention behind it, quite how it works in the middle of a service charge year in particular. And I will come on to this when we look at how paragraphs 9 and 10 work. I understand the broad thrust of your Lordship's point, but it's the same with paragraph 9. And this is what the President did in this case. Well, just look at the words paragraph 9. No service charge is payable. It means what it says. It appears straightforward and simple, but it isn't in practice.
Yes, I see. Thank you.
I would just say we're clear about the significance. Whatever one might infer from the reference in this parliamentary record is not suggested that it is admissible on a pepper and heart basis for either side's benefit.
I say it isn't.
Yes.
Yeah. All I'm saying is there's no clear statement within it upon which any weight could be given. The only point of taking you to that extract is to say the consideration of retrospectivity was limited, but I don't see you can take anything from it other than that because it's just not clear. It's not a clear enough statement. Can I take you briefly to Benyon? It's in the core authorities bundle at page, starts at page 413. Section 24.14. And I'm not going to ask you to read it all now, but it's page 415. The extract of Lord Justice Brooke's judgment in Flora and Wacom.
Which you'd like us to read.
I'm not going to. There's quite a bit there, so can I refer you to it? But there's no need to look at it for now because I don't think it's controversial. But what I would like you to read now is then over the page 416, under the heading "Which versions of the notes may be used." It's curious, of course, that the courts haven't considered that distinction to date, but there we are.
Well, as Benyon says, in practice, changes are often relatively minor. And you
Yes.
say this is a case that is the exception.
Yes.
We have to bear in mind that even if you've got explanatory notes which accompany the bill, it's not Parliament talking.
No.
But I think what Benyon explains is that they are often drafted by officials of the department to explain the policy thinking.
Yeah. Often under great time pressure, I think.
Often under great time pressure. And it helps to explain sometimes the mischief at which the legislation is targeted. I noticed when you took us to the explanatory notes accompanying the Act, that in the next bullet point it did talk about an explanation of the policy thinking.
Yes.
So in that respect, limited respect, there may not be a great difference between explanatory notes prepared with a bill as opposed to those which follow the Act, if you're only using it to look at the mischief or the policy.
My Lord, yes,
I mean, in any event, they can't supplant the words used by Parliament, whether it's before or after.
Yes, my Lord, agreed entirely. However, the extent to which the purpose of this bill was to protect leaseholders changed significantly during its passage. So there is a change in the purpose, really. It's worth bearing in mind the actual explanatory notes to which the judge had reference to in this case, the post-act explanatory notes, they weren't published until the 11th of August 2022, about 3.5 months after the Act received royal assent, slightly after the 3-month period for a JR, but that may be a coincidence. But that's the first time you get this express reference to retrospectivity.
And I didn't get the date. Were published until
11th of August 2022.
Yeah.
So really, we say those notes post the Act, they're seemingly effectively rewriting history. It's the first time we get an express intent of retrospective effects of these provisions.
Excuse my ignorance, but in what form are the explanatory notes published? It's implicit in what you said that the Queen's printer's copy, which is what actually is the text of the Act as passed and as it receives royal assent, doesn't contain any notes. So
It can't
where does one find the explanatory notes?
on the government website. I think everyone was searching every day for them. When
Well, if you go to UK government legislation, there is a tab often for explanatory notes.
there is, and on the page for the bill.
And presumably it's the notes accompanying the Act rather than the bill, or can you get both?
You can get both.
And if you want the bill notes, I think you have to go to the Houses of Parliament website.
I think that's right. Yes, that's where I've gone anyway.
Thank you.
what I say is perhaps surprising is the Secretary of State's evidence doesn't address that delay in the explanatory notes being published, so we don't have an explanation for it. But I do say that there isn't sufficient reasoning in what is said in those post-act explanatory notes to justify the conclusions that they seek to draw, that the bold assertion that service charge demands can just be torn up. It simply doesn't explain it. And for example, if we look at some of these explanatory notes in the core authorities bundle, page 404.
Did you say 404?
404, my lord.
Thank you.
So just, it's paragraphs 1757 to 1759. But just to take an example, you can see at 1759 the notes refer to costs already incurred by leaseholders. The costs are never incurred by leaseholders, they're incurred by the landlord. They might be paid by the leaseholders. So it simply doesn't make sense in the context of landlord and tenant legislation to have explanatory notes referring to costs being incurred. So there appears to be a lack of understanding on the part of the draftsman as to quite how these provisions all operate in any event. And then if you go up a few pages to page 390, this is where you get the reference to retrospectivity, paragraph 986.
Sorry,
390. So they don't explain. There's no reasoning given, is my point. Paragraph 986. It simply doesn't explain.
The criticism you made of the previous paragraph a moment ago, you said these costs aren't incurred by
Leaseholders.
That's a comment on paragraph 5 of Schedule 8, isn't it? It's talking about the maximum. Or did I misread it?
404.
404.
Yes.
Yes.
Well, yes.
And as you were pointing out a moment ago, paragraph 10, machinery,
Doesn't apply.
doesn't apply to paragraphs 5 to 7.
Yeah.
It applies to 2 to 4 and 8 and 9.
Yes.
And when you turn to paragraph 5, the opening words are, it refers to sums which are otherwise payable.
Yes.
Payable by as a service charge by the leaseholder.
Otherwise,
So
being
in
the
other
reference
words,
to
these
the other.
are sums which have passed through all the sieves you get in paragraphs 2 to 4,
Yes.
and I'll get this wrong, 8 and 9, they're otherwise payable, and then the maxima kick in under paragraphs 5 to 7, if I understood correctly.
Broadly, my lord, yes. Paragraph 9 doesn't affect the cap in paragraph 5.
No, I was trying to say that.
Yeah.
I'm sorry if I managed not.
But you go through 2, 3, 4, and then to 5. I think
That
is how
might
it's.
explain why the official in the department used the language that he or she did at page 404.
We don't know, but I think landlord and tenant lawyers, and this is an explanatory note about landlord and tenant legislation, would not consider leaseholders to be incurring costs. Was really my sole point.
Maybe it's written too properly.
I think really that's all I want to say on the explanatory notes. My point is no real weight should be given to them. And of course, we touched on this earlier. I say the same about the Secretary of State's own subjective intent as set out in the witness statements when we're dealing with orthodox construction that is equally inadmissible.
Well, you say it's more inadmissible. I think
Even more, yes. Well, it's entirely inadmissible as opposed to admissible, but no weight should be attached. Can I turn now to paragraphs 9 and 10 and what they mean? If I can take you to the core bundle, page 31.
And you do mean the core bundle, not the core authorities bundle?
Core bundle, my skirt and I.
I see.
These are the three options, if I can put it that way, for how the Act might operate. First option, what we call a prospective construction, it applies only to legal costs and fees that were incurred after the provision came into force. That's my principal position. Second option is what we've described as the intermediate construction. So namely, if costs became payable before the Act came into force, they continue to be payable. But if you hadn't jumped through all of the hoops to make them payable, i.e. served a valid service charge demand in accordance with legislation and the lease, then costs that you have incurred are lost.
When you say payable, you don't mean payable by the landlord to their solicitors, you mean payable by the leaseholders to the landlord.
Payable as a valid service charge demand.
Yes.
Because there's lots of hoops you have to jump through. You have to have passed the contractual mechanism. You have to have got to the year end. You have to have calculated the balancing charge. You might have to certify. Then you have the statutory hoops. You have to have a Section 47 notice. You have to serve it with a summary of rights and obligations, so on and so forth. The third option is, of course, the one that the Upper Tribunal found. We call it the retrospective construction. I dare say the President would say it isn't because it's not retrospective, but we're calling it the retrospective construction. So that is, it applies to any costs that were incurred, even if they'd fallen due before the provision came into force. Simply you tear up your bills. I referred to this earlier, but we all understand in broad terms how service charge provisions work better than most, and they're sort of simple to explain until you start getting into the detail and you look at the precise dates when things must happen. Compounded by every lease is different, and you have different mechanisms in different leases. This legislation operates in that context. I just want to very quick rattle through a reminder of the 1985 Act, and it's important for two reasons. One is it's the relevant context to protecting people from paying service charges, but the second is paragraph 10 expressly imports sections 80 into 30 of the 1985 Act into its operation. Section 18 was handed up. It's one of the loose pieces of paper handed up earlier. This is important because it tells us what relevant costs are. And that's in 18 subsection 2. there won't be any dispute that legal costs incurred in respect of a dispensation application are costs that would fall within the category of relevant costs. When we turn to paragraph 10, we'll see that paragraph 10 says they will no longer be relevant costs. For section 19, if I can take you to the first of the Hippersley authority bundles, page 8. You should have there section 19 of the Act. That's one of the chief ways in which leaseholders are protected from excessive costs. Relevant costs should be taken into account in determining the amount of service charge payable for a period only to the extent they are reasonably incurred, and where they are incurred on the provision of services, carrying out of works, any services with a reasonable standard, and the amount payable shall be limited accordingly. So the relevant costs cease to be taken into the account to the extent that they have not been reasonably incurred. And then you can see at sub 2, where a service charge is payable before the relevant costs are incurred, no greater amount than is reasonable is so payable. And then you have an adjustment. So it affects budgeted sums, on-account sums, as well as final sums.
I can't remember whether this was the first time Parliament enacted a reasonable constraint on service charge costs.
No, it goes back, I think, is it the Housing Finance Act 1972?
Yeah.
So it's
the reason why I asked the question is presumably when it kicked in, whether it was in 1972 or 1985, did it apply to leases which had already been granted?
Well, we did, as far as we can see, nobody ever argued the point. They did have a hunt for this on Friday when I had the same thought.
I'm not asking about whether it applied to service charges or costs before the commencement of the Act, but did it apply to deeds, leases, which already existed?
I believe so, yes.
Because then what Parliament was doing was qualifying an incident of a landlord's property rights.
Yes, yes. And this Act does as well, and there's no dispute about that. If we can then flick through from that page in the authorities bundle, you can see over the page you have section 20. You'll recall this is the requirement upon a landlord to consult leaseholders in respect of relevant works and qualifying long-term agreements, and if the landlord doesn't do that, there is a cap, £250 in respect of a set of works. And then over 2 pages, section 20ZA, that's the ability to apply, as the landlord did in this case, for dispensation from the need to comply with any or all of the consultation requirements. And the tribunal can make that determination if satisfied it's reasonable to dispense with the requirements. That's relevant, of course, also to ground 1, because the nature of the dispensation application is that you're not required to comply with the requirements. It's not a determination of liability. I'll come back to that. And then we see section 20C, which we don't need to look at, 21B. And then if I can take you to section 27A, it's page 16. This is how a party to a lease, landlord or tenant, can seek a determination from the tribunal as to payability. So when we're talking about whether something is payable, the tribunal can determine if it is payable, and if so, how much, to whom, the date, the manner. You can do that after the event, subsection 1, or in advance, a prospective application under subsection 3. And importantly, if you look at subsection 5, the tenant is not taken to have agreed or admitted any matter. That would then take it out of the jurisdiction of the tribunal by reason only of having made any payment.
Why is that significant?
Well, if I can come, I'll deal with that when we come to retrospectivity. But in broad terms, it's important because there is at least the possibility that a leaseholder could go to the tribunal now and say, this sum I paid in 2018 for a waking watch in my building is not payable because the Building Safety Act says it isn't. And just because they've paid it doesn't mean they can't get a determination from the tribunal that it is not payable if the Act has retrospective effect. That's the significance. I'll expand upon that,
yes.
if I may.
It doesn't necessarily follow. I mean, it might follow, but it depends on how retrospective it is.
Agreed, yes.
So the concept of payability is not just simply dependent on whether a sum falls within the words of a service charge provision of the lease and whether a demand has been served. It's also qualified by what we've seen in section 19 and section 27. That goes to payability.
Yes. And also more simple things like section 47, the need to state the landlord's name and address for service. That's if one looks at section 47, that says that you can't enforce payment of that demand because you haven't complied with it, with section 47.
But the reasonableness test goes to quantum.
Yes. Yes. Yes, it's not an all or nothing. It's you can reduce it proportionately. Can we then turn to paragraph 9? Which, as I say, there was a loose leaf copy handed up, if that's easier to refer to. Nothing turns on it, but it's worth noting subsection 1A and 3 and 4 are additions that came in July 2024. They didn't exist at the time the Upper Tribunal reached its decision. I don't think anything turns on it. Our focus is on subsections 1 and 2. The phrase used is no service charges payable in respect of the things that follow. And for the purpose of ground 2, I say, well, what does no service charges payable mean? And really a key distinction between us all is, do you just read it as no service charges payable, or do you turn to paragraph 10 and read the definition of what no service charges payable means? Because paragraph 10 gives us the answer. You see in 10.1 it supplements paragraphs 2 to 4, 8 and 9. At sub 2, we're told that those words used in paragraph 9 and in the other paragraphs mean no costs incurred or to be incurred in respect of that thing or in respect of that thing and anything else are to be regarded for the purposes of the relevant provisions, that's sections 18 to 30 that we just looked at, as relevant costs. That was that term defined in section 18 sub 2, to be taken into account in determining the amount of a service charge payable under the lease, or are to be met from a reserve fund. And you'll see the definition of relevant reserve fund really means any monies held on account. It doesn't really mean reserve fund in the sense we traditionally think of reserve fund. It just means any monies held on account. My overarching submission is that mechanism is at the very least ambiguous as to retrospectivity. the respondent submissions, this is at paragraph 23 of their skeleton argument, put the emphasis on the word payable in paragraph 9, rather than the emphasis on paragraph 10, which defines what no service charge is payable means. That focus on paragraph 9 is also broadly how the President approached the issue as well. We just turn to the decision, core bundle, page 205. Paragraph 151. So what he says is, well, just looking at paragraph 9, it's not framed by reference to the incurring of costs. That's the last line. And of course, a matter of express language, that's true. Paragraph 9 isn't framed by reference to the incurring of costs. But even if you entirely ignore paragraph 10, which I of course say you can't do, and just focus on the words used in paragraph 9, I still say it doesn't expressly make clear whether that applies to sums that were already payable prior to the Act coming into force, or only or whether it applies to costs where a right to payment had arisen, so you've incurred the costs and they will become payable, or whether it applies to any service charge demand, irrespective of when it was issued. It's silent on the point. There are no transitional provisions. And if we turn over to turn over one page to paragraph 161. This is where the President's considering what we call the intermediate construction, or in here I think it's referred to as my alternative submission. He was initially attracted to the idea, well, if you look at paragraph 9, no service charge is payable, it isn't necessarily affecting demands that were already payable before they came into force. It might be simply preventing sums becoming payable. He says there's some logical attraction to that. It would avoid some of the anomalous results, which I'll come on to in a moment, around the date of payment.
Just to confuse matters, I'm working from the report. So which paragraph are you in?
161.
Yep. Yes.
And when we come on to retrospectivity shortly, I'll take you to some examples where in the Act Parliament's made plain that the provisions were intended to have retrospective effect. There's a number of examples in the Act where it's made plain. This isn't one of them. The wording of paragraph 9 is in the present tense. It doesn't expressly state what happens to sums that are already payable, that have already been incurred. If sums were already payable on the 28th of June 2022, it isn't obvious that Parliament intended them to cease to be payable, because that would lead to some odd results. That's what the President's accepting in paragraph 161. You know, we had the example earlier, well, if the landlord's done works and he's demanded them validly from leaseholders prior to the Act, only some leaseholders have paid and others haven't. Whether they can't afford them or whether it's deliberate, it doesn't matter. In most instances, they wouldn't be able to afford it, will be the answer. It doesn't matter the reason. Some have paid, some haven't. That creates an inequitable situation. It's described as an unattractive result by the President. that likely to be intended? That's the question I pose. But we can't just focus on paragraph 9. We've got to look at it in the context of paragraph 10. So the focus on just those words in paragraph 9 is, in my submission, academic. Paragraph 10 has to be there for a reason. It has to do something. But at paragraph 153 of the President's decision, just turning back a page again, his conclusion was, it seems to me paragraph 10 contains the mechanism by which the result is achieved. I do not think that it actually changes or affects the opening words of paragraph 9. If paragraph 9 achieves what the respondents say it does and what the Upper Tribunal said it does, you don't really need paragraph 10.2a, or probably 10.2b. It's a complete answer on their analysis. The service charge demands are simply not payable. Why do we need paragraph 10? Parliament clearly considered we did need paragraph 10, given it's there. So we need to think about why do we need it? So we think, well, what is the nature of a service charge demand? A service charge demand is a sum payable by a leaseholder to the landlord or the manager in respect of a bundle of different types of costs in most examples. Window cleaning, insurance, management costs, whatever it is. Some demands will be an amount on account, an estimated sum. Sometimes there'll be a balancing charge. Often you've got enough on account that you don't need to issue a balancing charge and you instead will issue a credit. Service charge accounting is complex. If you paid for legal costs out of a reserve fund, the way in reality it would work is you'd have to transfer money from the reserves to the income for the year, and then you'd have to account for the legal expenditure. So you probably don't need the provision in section 10.2b for providing for use of reserve funds. I don't think anyone would doubt it's good for the avoidance of doubt to remind landlords you can't use reserve funds for future expenditure. The important point is you have that balancing exercise. Not in every lease, but in almost every lease. And paragraph 10 is doing this by well-known, well-understood concepts in landlord and tenant law, which we've gone through already and are incorporated at section 10, subsection 3. So let's look at the words used again in paragraph 10. At 10.2. The phrase used is costs incurred or to be incurred. Want to pause there. That can't be read as mandating a retrospective effect in itself. That phrase, costs incurred or to be incurred, is being used to encompass both budgeted on account sums and year-end charges, balancing charges. It's the same form of words that was used in section 19.
It's also the same form of words as used in section 124 in dealing with the contribution orders.
Yes, I think
when we get to the retrospectivity argument in the second appeal,
yes.
A lot of the arguments seem to hinge on the use of those words there.
Yeah.
And it's being submitted in that case that they don't have a temporal dimension, or they're meant to exclude temporal limitation.
I say they're being used here in the same way they're used in other places in land and tenant legislation, which is to refer to capturing costs that have been spent during the year, i.e. a balancing charge, or costs that you are charging on account, i.e. budgeted sums. As we all know, normally you'll have 1 or 2 or maybe 4 payments during the year. So the landlord sets a budget. Payments, 1, 2, 4 payments are made through the year, and then at the end of the year you look at what's in fact been incurred. and you work out what the balancing charge is. So I say that's all that reference is. I won't comment on the interplay with section 124. It doesn't arise in this appeal. That's for others. So from the 28th of June onwards, I say, you would exclude impermissible relevant costs from the service charge accounts when you're determining the balancing charge, because a cost that's been incurred in respect of impermissible legal costs is not regarded for section 18 to 30 purposes as a relevant cost when you perform the accounting procedures. That only applies in my submission for when the Act comes into force. So we have a service charge year beginning on the 28th of June 2022 onwards. If you're setting a budget for that period onwards, you cannot include within the budget any costs of a prescribed type, here the legal costs caught by paragraph 9. You have to disregard those costs. You can't include them in the budget. You can't take them from a reserve fund, so you can't spend it out of money that's already been held on account. And when you get to the year end, you can't include those costs that you've incurred in that year. But then paragraph 10b tells us the amount the landlord can lawfully demand, that's what would make it payable for the paragraph 9 purposes, is limited accordingly. And that's the wording that you see in section 19.1, so they all dovetail together. The reference to the words limited accordingly. The focus is on the costs incurred, not to the date the sum was rendered payable. That's what the meaning is of no service charge is payable, and that's how that phrase is given effect. If we give a hypothetical example, broadly based on the costs in this case, but it is hypothetical. Landlord in this case knows towards the end of 2021 that there's a dispensation application afoot, and it's instructed solicitors, and it's going to be liable to pay those solicitors. And we know the hearing is in December 2021. Bills haven't come in yet, but the landlord has to set a budget for 2022. It's only when the appellant is billed by its solicitor that will have incurred the costs. That's a case called Brent and Shulam B. It won't be in dispute between us. The costs are incurred when you get the bill for the purpose of the service charge legislation, broadly speaking. But you know that bill's coming. So you include it in the budget for 2022, and on-account demands are sent out at the end of 2021, payable on the 1st of January 2022.
Is that because of the words to be incurred?
Yes. Yeah. Well,
you foresee that they will be incurred, and the word
yes.
to be incurred covers that.
Yes.
So really, the retrospectivity argument hinges on the use of the word incurred.
Yes, well, it hinges on whether it captures costs already incurred before.
Prior to commencement.
Yes, or to be incurred. But budgeted for or in fact incurred prior to commencement. You might find that you might take the view it only captures those that are in fact incurred. That's really our concern.
And in your hypothetical case, you've sent out your on-account demands, did you say the beginning of January?
Yeah, let's say they're sent they're sent out in December, payable on the 1st of January 2022. That would be a typical example. Some people will pay them, some people might not. You've had a contingent liability to the solicitor to pay for the cost of the services they've provided for some time. That crystallises when those bills come in from the solicitor, let's say in February 2022. That's the date you're said to have incurred the cost in the landlord and tenant legislation, albeit it was inevitable that you would incur it because you'd asked them to do the work, say, 6 months earlier. Your position under the lease is you're entitled to be indemnified against that cost. This is all really relevant to the retrospectivity point. Where does it kick in? If the service charge year ends, as it does in this lease, on the 31st of December, you can't render those sums payable until some point in 2023, because you've got to produce a set of accounts and send out a balancing charge to the extent that your expenditure has exceeded the amount you've got on account. Maybe you got enough on account, maybe you got more on account than you needed. In that case, you will never send a balancing charge that encompasses those costs you spent on legal fees. If the Act works in the way the Upper Tribunal says it does, if there is a balancing charge to be paid in respect that encompasses an element of those legal fees, that balancing charge is not payable to that extent. Well, how do you work out to what extent it's not payable? It doesn't tell us. It's part of a big basket of costs. But equally, let's say this lease had a different service charge year, and the service charge year ended February 22, and you got your balancing charges out before the 28th of June 2022, you might have rendered that sum payable.
So just to understand, in your previous case, you've budgeted for the legal costs and therefore claimed money on account in respect to the legal costs. Then along comes the Act. There you say, if it turns out that you need some more, you won't need more in relation to those legal costs, I suppose, not the ones you budgeted for.
Well, that's the question. I suspect Mr Loveday would say it's all part of the overall costs that you've incurred at the end of the year, and you discount from those accounts the amount you spent you in fact incurred on legal costs during the year, and you reduce the balancing charge accordingly. But that doesn't answer the question how that works if you in fact had more on account than you needed.
Does it not? I mean,
there is
will you not still strike out somewhere an entry and it will feed through into subsequent accounting?
Not if you only focus, as he does on paragraph 9, because it's focusing on whether sums are payable. And if the result is you would have got a different credit, that's not a sum that's payable. That's the difficulty. That's why you need the paragraph 10 mechanism, because, as I said earlier, service charge accounting is simple at the start, but it's quite complicated when you start working things through, because there's an infinite number of possibilities. I mean, to take my example, the broad point is whether or not you get paid depends on when your year end is and whether the leaseholder has paid promptly or not. And that, in my submission, seems somewhat arbitrary and unfair. And the starting point ought to be Parliament's not going to have intended so it's arbitrary and unfair. Or at least if it did, it would be obvious and it would make that clear. Of course, I accept there will always have to be a date when legislation starts, and that will be arbitrary usually. No dispute about that. But on the respondent's construction, it's pot luck what the outcome is. You can't plan for it. Late payers are rewarded, prompt payers are not. Landlords who have sought to protect leaseholders from having to pay the cost lose out. Those that enforce payments immediately are better off. Well, the government was encouraging landlords to do the right thing and not enforce payment of these charges whilst they pursued third parties. That's what a lot of landlords did, including this one. Again, that doesn't make any sense for Parliament to have intended such an arbitrary outcome.
Well, presumably, you say that's what this landlord did, but as far as these costs are concerned, legal costs incurred in the dispensation application, you didn't include them in the service charge demands because you were told by the first tier you couldn't.
Well,
you had to appeal that, well, first get it reviewed,
yeah.
and then they said, okay, we were wrong about section 20C, but we'll stick a condition in anyway. So you still couldn't include it. Then you had to appeal that, and by the time you appealed it, the act had come in. So there was never a stage at which you demanded these costs before the act came in.
This doesn't appear in the document. My instructions are, in fact, it was included because it was under appeal, because otherwise you lose the ability.
Oh, I see.
Landlords will tend to include it and then deal with it once there's a final outcome to the case, and that's a portion of the costs were incurred in the 2021 year and bills before the Act came into force. A portion of them were incurred in the 2022 year and wouldn't have come payable until 2023. And I think effectively what then has to happen is the landlord serves section 20B subsection 2 notices to preserve its position, because there's a strict 18-month limitation period. The statutory overlay is enormous on landlord and tenant legislation. It makes it very complicated to deal with these sorts of situations. Point is, you can't plan for it if it has retrospective effects and the outcome is arbitrary. On our construction, where it's addressed, where you focus on costs, the date costs were incurred, you don't get that. You do get a hard cut-off, you get the bright line that the Secretary of State was looking for, but you don't get those arbitrary outcomes. The fact it's producing unfair results, I say, should be ringing alarm bells. Is there another way of reading the provisions that would address them? And of course, I say yes by focusing on when the costs were incurred.
I just wonder about the position of the early payer. If you go back to paragraph 10(2)(b,
Yeah.
the amount, as you pointed out, the amount payable under the lease is limited accordingly. And then in brackets it says, and any necessary adjustment must be made by repayment. So why wouldn't the early payer be able to take advantage of that? And indeed it gives other options, reduction of subsequent charges or otherwise. It's pretty broad.
My lord, it is. It doesn't really explain to us quite how it works within the context of the lease.
Because that would apply if your reading of the statute is correct, and this is entirely prospective. You could get a situation where an amount has been demanded and paid, which the landlord wasn't entitled to, and this is saying, well, the early bird can get it back. But doesn't this end up as being neutral? Because why wouldn't the same apply if it's retrospective?
Well, yes, I see that. I do see that point. The reality is section 27A1, and we looked at section 27A5, says even if you've paid, it doesn't stop the tribunal from reducing the amount that's payable. But really it's just dovetailing with that. Broadly, what I say is this: a construction where you focus on the costs that have been incurred. It removes the unfairness and unequal outcomes. You're still giving effect, just thinking here about statutory purpose, you're still giving effect to the building safety reset. This isn't impacting on the protections going forward. The park protections are as Parliament intended. We're not challenging those. From the date the Act came into force, the protections are in place. And I say it accords better with Parliament's intent based on the words used and on the assumption that Parliament's unlikely to have intended arbitrary or unjust results unless there was some clear indication otherwise. The wider context is that the BSA is not about punishing landlords in any way. The purpose is, yes, about protecting leaseholders, but the position on retrospectivity is not expressly addressed. It's about ensuring that those who are responsible for the defects pay. You'll see reference to the polluter pays principle, which we see in various places through the Act. and making sure that buildings get remediated. And that really is the most important purpose. You can get some very odd outcomes with the retrospective effect. We have to remember not all landlords, or as per the appellant, are an institutional investor. Just as common, if not more common, is the position where you have a residence management company, so a named resident-owned management company responsible for the building, or a right to manage company. And those are poorly funded, on the brink of insolvency generally, companies, because they have no trading income, they're entirely reliant on service charge provisions. So what about their position, where they've incurred costs prior to the Act coming into force?
I mean, I follow that could be tricky, but are they not in a mess anyway for the future?
Well, that's a whole that's unravelling an awful lot of debate. They are, but they can plan. The point is, from the date when the Act comes into force, they will not incur a cost unless they know they can pay for it, and that way they can avoid insolvency.
Is that right?
So what
Do they not have contractual obligations? Do they not have to carry out certain works?
Yes, but if they spend money they don't have, then they're going to be insolvent. So they've got two options. One is to get the money in on account before they spend it. The other is to spend money they don't have. Well, that's not an option. And
I mean, they're going to be insolvent either way, aren't they? Either they have contractual obligations they're not fulfilling, and therefore they're insolvent, or they fulfil those contractual obligations and can't recover the money, and they're insolvent that way as well.
They're in a very difficult position, and that's one of the reasons, for example, you see those carve-outs and the additions to paragraph 9 that then carve out the ability for such companies to then be able to fund the costs of applications against third parties to recover, to get monies in to pay for remediation. For example, there is ability under some of the statutory instruments for them to try and serve notice on a landlord to get a landlord to pay for their costs, albeit those statutory instruments didn't exist at the point when Part 5 came into effect. There are ways, particularly for the future, to do it, but they are in a particularly tricky position with respect to costs they have already incurred before the Act came into force and before even these provisions were published.
And just to be clear, are you going, you said, well, we find the same sorts of wording recurring through Schedule 8. So we're not just dealing with professional costs.
No. Because paragraph 10 applies to paragraphs 2 to 4 and 8 and 9.
Yes. And are you going to be coming on to how your construction would fit in relation to those other paragraphs?
Well, I wasn't proposing to, simply because I say it works in exactly the same way. It doesn't matter. It's either it's the cost of cladding remediation,
yes,
or it's the non-cladding, it's the remediation, relevant measures in respect of the relevant defect.
I follow. So let's take cladding remediation. Yep. Remediation. It turns out that there is a building that has a cladding problem. The landlord potentially has a contractual obligation to effect the remediation, presumably.
Or the manager, depends who has the obligation for statutory compliance.
But let's make it easier. See, the landlord has a contractual obligation to effect the repair.
Yeah.
On your case, they can't put that against the service charge for the future.
Correct.
So they're in a mess to that extent. At least if they're the sort of landlord that is only getting in a ground rent, then they've got a problem.
Yes.
But looking at it in other terms, supposing that you are right, then the leaseholders have very limited protection, do they?
In respect of costs already incurred?
I suppose only in relation to costs already incurred, yes. So
there's no challenge to putting aside,
yes,
you'll see amongst the witness evidence enormous amount of debate between the appellant and the Secretary of State in particular about how in practice these provisions are meant to work and whether they're fair and everything else, and Mr Birdley will no doubt come on to that. And there are real difficulties, we'd say, with the policy, but that's not the focus of what we're dealing with here. But there is a big difference between having spent money and then being told you can't get it back, but having spent it at a point when you had every entitlement to think that you would be entitled to be indemnified against that cost because you have a contractual entitlement to it, and the government's encouraged you to do the right thing and everything else. And the position going forwards where you're told this is the date, 28th of June onwards, this is how the scheme will work. And it's really important to remember that this comes alongside also changes in how you assess what needs remediating and what's called the developer pledge, where an awful lot of buildings are then pulled within what became the developer remediation contract in about April 2023. So to take the example of this building, the appellant was at a reasonably advanced stage in terms of its remediation plans, and the building was within the Building Safety Fund. It had received monies to help it work up a scheme of works, the ability to go for a tender. At the same point as the Building Safety Act is brought in, you have the developer pledge and changes to how you assess external walls of buildings, so the introduction of what was called PAS 9980 as a standard, a risk assessment standard. And effectively what happens is remediation stalls, unfortunately, so that the building is still not remediated because there is a developer that signs the pledge. It then takes a year for the Secretary of State to sign a contract with the developer. Nothing should be read into what I'm saying. I'm just trying to state facts here. It took a year, and I think it's the 30th of June. You have it's the last page in the supplemental in the additional bundle. There's a letter from the developer that says, from the government that says the developer has taken on this building. We're withdrawing this building from the Building Safety Fund, and the developer is going to resolve everything. That's sent in June 2023, and here we are in 2025, and the developer is still arguing about what works actually it needs to do, because the incentive of any developer is to reduce the scope of the work.
I mean,
so that is the reality of it.
I see all that. Just coming back to retrospectivity.
Yeah.
You say, well, at least once the Act is there, landlords know where they are. So when they incur costs, they know they're not going to be able to get the money back. But in relation to contractual obligations to carry out remediation works, they haven't got a choice. I mean, if they choose not to do them, that doesn't excuse them from doing them.
No, and it's a statutory obligation more than that.
Yeah.
They don't. But landlords and managers are left in a difficult position because they can't really get on and do the works because they're waiting for the developer to do it. So local authorities will enforce the statutory requirement to fix the building, and then the building owner says, but the developer's meant to be doing it. Yeah.
So in terms of retrospectivity, following on from my Lord's question, you have on the one hand, case A, a landlord who has done the works before the commencement date and incurred the costs.
Yep.
Having thought before February 2022 that nothing like this was going to turn up in the law, as opposed to case B, a landlord who hasn't done that before February 2022, but in any event has the liability, and before that date wouldn't have thought the liability was going to pan out in this way. They would have thought beforehand that they would be able to recover the costs from the tenants.
Well, yes. I mean, the liability to remediate hasn't changed in that period. It's often thought the Building Safety Act imposed one.
Thought they were going to be able to recover from the tenants via the service charge mechanism.
Well,
and both had that expectation disappointed.
Well, I accept that, but one had the ability. One incurred the costs. Let's say the works were done in 2019. One incurred the costs and, for example, might have held off on recovery of payment. This is exactly what Mr. Anderson explains at paragraph 16 of his witness statement. It's in fact happened on at least one of their buildings, I think multiple buildings. You know, they held off on enforcing payment. So they serve a Section 20B2 notice to preserve their position, or they'll serve a demand and say, but we are not actively pursuing recovery of this whilst we pursue third parties, because that's the fair thing to do. It's the right thing to do. So the position is different. It's also different because it's a different context when you have the developer pledge. When you look at the overall position across, say, a large portfolio where lots of the developers are then kicking in and will be assisting, not on all the buildings. There are still, as Mr Anderson explains, lots of buildings where they're still having to incur the costs, but it's a different picture. I'm conscious of time. Yes. Even if I steal a small amount of Mr Birdling's time, I must finish by 1.
Yes.
Or he will not have enough time. The final thing I wanted to say, I'm going to focus a bit more on retrospectivity in a moment, and I've got to touch on the other ground as well. I said there was a point of crossover with triathlon. In the context of the wider scheme, depending on your decision in triathlon, it might be a good submission for me also to note that there's no need in policy terms for Schedule 8 to have retrospective effect. Because if it's possible to seek repayment of sums incurred prior to the Act by way of a remediation contribution order under Section 124, in policy terms, what justification is there for Schedule 8 applying retrospectively? I'd accept that the type of costs that can be refunded via a remediation contribution order and those prohibited by Schedule 8 are not 100% aligned, but they are very close. The fact that the tribunal must consider it just and equitable to make an RCO might be considered to address in part the unfairness that results from a complete retrospective effect. I should be clear, I don't say that is how Section 124 operates. That's for the other parties to argue, and I don't want to wade into that. But if the outcome of the triathlon appears to find it can apply to costs already incurred, that may feed into, in policy terms, whether Schedule 8 was intended to have retrospective effect.
And just taking that hypothesis, where would you be placed if Section 124 had that retrospective effect? I don't mean in service charge terms. What steps would be open to you?
Well, my point is more it would be open to leaseholders to apply to the tribunal for a remediation contribution order against my client for a repayment of the sums that they had to pay in respect of costs incurred before the Act came in. It would also be open to my client to seek a remediation contribution order from a developer or an associate of a developer.
And that's the aspect I was just thinking about, and that might be said to count against you. So be it, you can't get the money from the service charge, but it's all right because you have the ability to pursue someone else.
Yes, but in my submission, that's not such a strong point because we have a contractual indemnity with the leaseholders. We've spent money as a point where we have an absolute entitlement subject to jumping through the hoops to be recouped the money. My client doesn't have any relationship with the developer. And it can't be assumed the developer exists. I mean, they do in this instance.
But yes, I could quite see that point.
I mean, can I just sort of summarise the construction point this way? My starting point is to say it's simply read properly, the effect of paragraphs 9 and 10 is that they only affect costs incurred after the 28th of June 2022. I say that's the proper way to read it. But at the very least, I invite you to find that is a reasonable way of construing the operation of these provisions such that there's ambiguity. At the very least, it's not obvious when you read paragraphs 9 and 10 together that a retrospective construction must have been intended. You're familiar with the principle against expropriation and Horner. You know, we've got to assume that wasn't intended unless we're obliged to construe it in that way. just take you to a few authorities on retrospectivity before I finish up on this ground, if I may.
Can I be sure I've written down correctly which costs you say are included in the costs? This is a construction of 10.2a, is it? Paragraph 10.2a. No costs incurred. You want to read in the words after.
From the 28th of June 2022, so from the date these provisions come into force, no costs incurred or to be incurred in respect of that thing are to be regarded as relevant costs.
Yes. And that's the only, I won't say change, but that's the only bit of the Act you need to construe. It's just what paragraph 10.2.
Yes, because that's defining what no service charge is payable means. In my sense. A few points of retrospectivity, if I may. It's common ground between the appellant and the respondents that on the respondents' construction, on the Upper Tribunal's construction, there's practically no limitation on how far back one might have incurred costs that are now no longer payable due to Schedule 8. Reminder, relevant defects go back 30 years. It will also be common ground that there is no limitation period applicable to applications under Section 27A for a determination as to whether a service charge is payable. And you'll recall that Section 27A5 told us it doesn't matter if you've paid the sums, that doesn't of itself prevent the tribunal determining payability. There's no need to turn to it, but it's the point we make at paragraph 53 of our skeleton argument, and the respondent's skeleton argument at paragraph 31(5) agrees. So on the respondent's construction, they say you could go to the first tier tribunal now for determination of the payability of a bill rendered in 2017, and the FTT could now find it's not payable by reason of the Building Safety Act. Can I now take you to a passage in Benyon? It's in the Core Authorities bundle, page 342. I'm looking under the heading definition at the bottom. And if I can ask you to keep going over to the top of 316 and the part you see quoted there from the AXA case.
You said 316, you mean 343, do you?
Sorry, 343, yes. I don't know where that came from.
Yes.
So we've got to be careful here about what we mean about retrospective effects. Nobody's disputing that the Act, that Schedule 8 affects existing contracts, it affects the existing lease. It's the point my Lord made earlier, it applies to an existing lease. But there's a difference between it impacting upon existing debts and it affecting the future ability to recover for future expenditure. There are different kinds of retrospective provision. Now, the Secretary of State's position, as expressed in her skeleton argument, is to say, well, the effect of paragraph 9, as the Upper Tribunal found, is in substance solely prospective. In my submission, that is not a correct characterisation of the position here. Not on the Upper Tribunal's reading of it. Accrued rights based on events that have already happened are written off if previously incurred costs and payable debts are written off. And we've got a really good example of this in the Wilson and First County Trust decision. And I want to take you to a couple of sections in there. It's page 616 in the Hippersley Authorities bundle.
Sorry, 616. Do you know which tab number it is?
It's tab 25.
All two.
I want to take you first to the judgments of Lord Scott at paragraph 161. Just a reminder, this was a case considering whether the Human Rights Act 1998 was retrospective.
So page.
Page 616.
Thank you.
It's at the bottom, paragraph 161. You can see that emphasised further in the judgment Lord Roger on page 622, paragraph 187. It starts in Wainwright and Home Office.
Yes, I see.
And if I may then, one final place, page 624. This is quoting from a decision of Lord Justice Buckley in a case called Western Gwyn. And I'm looking from B to the end of that quote on page 624. So this all illustrates, it's important to understand what's retrospective and the different ways in which the same provision might be argued to be retrospective. Now, my learned friend will take you, I'm not going to look at them now, will take you to a couple of examples that he says are analogous. There's a case called Sherra-Lambus that related to tenancy deposits, and a case called Thorn, Customs Excise and Thorn. I say properly construed. When you look at those two cases, those are concerned with provisions that are only affecting the position for the future. They are not examples of retrospective legislation. And indeed, in the Thorn case, the House of Lords expressly found so. The position with service charges is slightly more complex than in the examples in the case law. And that's because there's more hoops to jump through before payability is established. That's the distinction here. It's clear that a contingent right to be indemnified against expenditure arises the minute you, in this case, instruct the solicitors to represent you in a dispensation application. You'll then incur the cost in L&T legislation when the bill comes in. To make it contractually payable, you then must prepare a set of accounts, perhaps certify them, and send out a demand for a balancing charge. To be statutorily valid, you then have to comply with all the things you have to comply with. So there's lots of hoops to jump through. But the point at which that contingent right arises is when you instruct the solicitor to represent you in the case, because you're doing that as one of the services you must provide under the lease. You instruct the builder to fix the window or whatever it is. You're doing that because you're entitled to be indemnified. That's when that right arises. That is different from the position where post the Act, you know the position and then you incur a cost in that new legislative scheme. Perhaps you'd do things differently, perhaps you wouldn't. That's not the point. The key point is you have a contingent right to be indemnified from the minute you instruct, in this case, the solicitor, as long as it falls within the types of costs that you're entitled to recover. It's more than just a hope of being entitled to payment in the future on the happening of some unknown future event. The example of a wager and things like this, they're different. It's just a question of jumping through the hoops. And I say that analysis in Wilson is pretty clear. The Upper Tribunal's analysis of the decision, and you see this at paragraph 159 of the decision, just oversimplifies the position. Yes, the restriction only applies from the date the Act came into force, but the question is whether, properly construed, it was intended to apply retrospectively in the sense of effect your already accrued rights, things that had already happened prior to the Act coming into force. It plain in my submission has in substance retrospective effect. Overnight, tens of millions of pounds gone. Where Parliament intended the Act to have retrospective effect, it said so. Some examples of that: Section 130 of the Act, Section 135 of the Act, that's the retrospective change to the limitation period for a claim under the Defective Premises Act. It says this provision is to be treated as if it was always in effect. My Lord, it's Core Authorities Bundle, page 51. Section 149, a retrospective right to pursue product manufacturers. Section 149 uses a new 30-year limitation period created by a new Section 10B of the Limitation Act 1980. These provisions all have savings for convention rights, notably. Parliament's thought about, well, this has retrospective effect. How do we deal with that? Now, the Secretary of State's evidence, and indeed skeleton argument, seeks to suggest that the retrospection is a fundamental part of the policy underlying the Act. Again, what does retrospection mean? Perhaps that is so in the sense one sees discussed in the numerous department emails and memos as the policy was being worked out, whether it should apply to historic building defects or only to works done after the Act is brought into force. That was a debate we see in the evidence. But there's no debate that it was in, there's no discussion around whether it applies and was intended to apply to to costs already incurred. If it's a fundamental part of the policy, it's odd that there's no debate around retrospectivity. From what we can see, we looked at the Hansard reference earlier. There's no express words to make that intent clear on these provisions. There's no suggestion that the guidance for parliamentary draftsmen on retrospective provisions was followed. You'll find that in the authorities, Hippersley authorities at page 2403. If you intend it to have retrospective effect, you have to seek express. You have to jump through some hoops, parliamentary hoops. So if it's a fundamental part of it, it's at best unsatisfactory that Schedule 8 doesn't say that. And the overwhelming impression is that this precise issue simply wasn't considered until after that was passed. Well, our proposed construction gives an easy to apply principled approach to the operation of the paragraph 9 protections, and thus the protections of paragraphs 2 to 4 and paragraph 8. It removes the unsatisfactory discrepancies. It respects the presumption against retrospection. In both the Upper Tribunal in this case and in the triathlon decision, it's paragraph 78 of the triathlon decision, note it's unlikely all these inconsistencies would have been intended. I could just turn my back. Well, if I could turn now to the other ground, unless there's anything else I can assist you with on.
Could I just ask one question? The issue about retrospectivity or no, you're focusing on paragraph 9. Does your analysis depend upon paragraph 10, subparagraph 2?
Yes, because I say paragraphs 9 and 10 have to be read together.
Yes.
Yes.
But it's because of what we see in 10.2 that you present this argument, as opposed if 10 didn't exist, what would you say about 9 and its use of the word?
If 10 didn't exist and we were only looking at 9, which the approach to the Upper Tribunal could be said to have taken from the passages I took you to earlier, you're still left with the question, no service charge is payable. Does that apply to a service charge that was already payable before?
Of course, that phraseology applies in the other key provisions in Schedule 8.
Yes. Yes. They all use,
So you rely upon payable, but you say it's reinforced by what we see in 10.
Yeah. I say paragraph 9 equally doesn't tell us categorically one way or the other, and the presumption would tell us, therefore, it only applies to sums. But if you only read paragraph 9, it's more difficult. That still lends support for my intermediate construction, but if you ignore paragraph 10, it makes it more difficult to explain why it's tied to incurred costs that have been incurred or to be incurred.
Okay, thank you.
But,
Okay. Can I just understand the scope of your argument about section 27A of the 1985 Act?
Yep.
So, suppose that service charges have been levied and paid by reference, you say, to works carried out, we assume, in 2017.
Yep.
On your case, if the respondents are right, it would be possible for leaseholders now to go to court, well, to go to the tribunal under 27A and say, strike out these elements.
Yeah, it's a very common feature of section 27A1 applications for leaseholders to go back a long way.
Yes.
Because there isn't a limitation period. Sometimes that's dealt with in case management terms if people are, going back 20 years because simply the evidence doesn't exist. But there isn't a limitation period. And the tribunal can determine whether a sum is payable. It doesn't say whether the sum was payable, whether it is payable. I mean, it's curious, and this point, I don't want to accept the point because it might be a point for another day, but at least in principle, I understand the respondents and us to be as one on this, that in principle, if the Act has retrospective effect, then if you make an application to the Tribunal in 2025 for a determination of payability and the Act has retrospective effect, then it is determining today whether a sum is payable. And if it has retrospective effect, then that means that it can say that amount spent in 2017 is not payable, and therefore X. Now, the leaseholder might be in difficulties enforcing that decision because it wasn't a payment made under mistake, so you couldn't bring a restitutionary claim to enforce the payment, but they might say they can set it off.
Well, doesn't it say under 10.2b any amount payable is limited and any necessary adjustment must be made for repayment?
My Lord's point.
Yes, so you don't need to rely on a restitutionary mistake argument. You just rely on a statutory provision saying you've got to adjust.
But that wasn't Parliament's intention, because you'll remember it was said, I think it was even in the debate.
The explanatory notes, which you say we can't rely on.
No. I was thinking the Hansard reference.
I see.
Same point, but it said, well, they say, yes, we accept that none of this means that anyone has to repay anything.
So suppose, which must be unreal, a landlord immediately after the Grenfell Tower realised that their building had objectionable cladding on it. Yeah. Miraculously managed to find somebody to do the work just like that. Yes. And removed the cladding. Yes.
There are examples of that in 2018 and 2019.
Yes,
I was involved in cases.
And that were reflected in service charge claims very quickly, yes, I suppose. On your case, you say the respondent's argument would mean that a leaseholder could now come to the tribunal, say that those costs should be struck out, so to speak, with a consequential adjustment under 10.2b by repayment, reduction of subsequent service charges or otherwise.
Well, I don't think you need to, this is what I say, I'm not sure that's what 10.2b was intended for, because if you get a determination under section 27a that the sum was
then it feeds through anyway.
It feeds through in an established way. So
yes,
I'm not sure that's what 10.2...
No, I see.
And also, if 10.2b means what was suggested it means, you would have an automatic refund on the day the Act came into force of all the sums previously payable. That can't have been intended. If it means literally what it says and it has retrospective effect,
well, except
you'd be crediting it all back.
Possibilities, because it says
repayment, reduction of subsequent charges or otherwise.
Yes.
Yeah.
But it does say adjustment must be made. There's no discretion in any tribunal.
Well, if it has retrospective effect, that presumably applies to everything brought by the Act, going back to the year dot, which is, 30 years, at least. That can't have been intended.
Attention to the definition of relevant defect or whatever.
Relevant defect is it's a 30-year period, so it's back to 1992.
And so if you take paragraph 2 of Schedule 8,
yes,
a relevant measure relating to a relevant defect. So what could have been a relevant defect 29 years ago?
If you think about a building that's clad in Grenfell-style ACM cladding had a defect from the outset. Now, in practice, that's why I was using 2017 as an example.
Well, I can see why you use 2017, but you say, well, you can go back 30 years.
Yeah. Can I give a better example? A relevant measure in respect to a relevant defect, a common relevant measure in respect to a relevant defect is works to defective fire doors. Those works have been going on since about 2005 when the fire safety order came into effect. People have been replacing fire doors because it became apparent they weren't sufficient. That's a relevant measure in respect of a relevant defect. So it's not academic to look back prior to 2017. I'm not suggesting someone's going to be going back to a service charge demand in 1992. The point is, for a number of years, people have been spending money on relevant measures in respect of relevant defects. If you read paragraph 10.2b literally, there's a credit arises due in respect of all of those retrospective costs from the moment the Act comes into force. It can't possibly be right.
Yep.
So leave aside paragraph 10.2b.
Yeah.
Just the normal operation of the Landlord and Tenant Act 1985, in section 27A, you pay a service charge because you don't want to run the risk of being forfeited. But you immediately go to a tribunal and say, that's not paid. What is your remedy? Do you get it back? I mean, what's your remedy? How do you get it back?
All you get from the tribunal is a determination, effectively declaratory relief. You get a determination as to the payability of the sums.
Yes.
So the tribunal ought to give a precise amount that each leaseholder was in fact liable to pay, so maybe £100 less for the year. The way that's enforced by the leaseholder is either but there's three options. In the usual course of events, the landlord will just credit it back. So you don't, I mean, that is nearly invariably how it works. And, but in theory at least, and I have to say in my experience, it's very, very rare you get to that point. You would either issue a claim in the county court for repayment of sums paid by mistake, so a restitutionary claim with a 6-year limitation period, or if you are still the leaseholder, you would seek to set off against future service charge sums. Future service charge demands you exercise an equitable set off.
Would that be limited to 6 years?
No.
And it has to work that way rather than having any right to have the accounts reworked.
Yes.
Yes, I see.
So leave aside our Act, just under the Landlord and Tenant Act, where you accept there's no limitation period. In theory, you could reopen payments made over the last 30 years and then set them off against future service charges.
Yes.
Yes.
So let's say the landlord carried out recladding works in 2019 that have been charged by way of a service charge. A leaseholder could challenge those works and say they weren't done to a reasonable standard because some panels keep falling off, and the tribunal could assess that, and if they agreed the works weren't done to a reasonable standard, they might reduce the costs by a proportion. There are limits to that, because if you're taken by reason of having paid it without any objection for many years, you might be taken to be stopped from bringing bringing such a challenge, or you might be taken to have agreed the amount. But what subsection 5 says is just the fact that you've paid doesn't of itself mean. But there's an awful lot of Upper Tribunal authority over a number of years now that says, but if you have been paying these sums for a number of years and not challenged it, you will be taken to have admitted it. So the preference is to deal with it as an admission, an agreement, rather than on an estoppel basis.
And just thinking around things, could any of that help a landlord here when challenged for something that has ceased to be payable as a result of this act?
For the future?
Well, you say a way in which landlords have dealt hitherto in the tribunal with leaseholders coming along and challenging things that happened years ago is estoppel or agreement.
Sometimes, yes.
Is it open to them to run the same sorts of arguments in relation to things that now become challengeable on the respondent's case?
Yes. But it's more, yes, you'd run into some interesting arguments in an estoppel, I suspect, where the law's changed in the middle of the period. And, anyway, I'll keep my powder dry on that. Sorry. Yeah.
Lord, can I just
Yes.
say something briefly about limitation? It's not quite as simple as saying that there's no limitation period that applies. Current state of authority depends on who has made the application in the first-tier tribunal. If there is an application under Section 27A of the 1985 Act made by a landlord, there is a limitation period depending on whether it's treated as rent, whether it's action on a specialty and so on. But if the application is made by the lessee, it is not subject to any limitation period. That's the current state of play on the authorities. Hope
That's helpful.
I'm very cool.
Mr. Anderson.
Well, may I move on to
Yes.
the second round of appeal? I'm going to do this in less detail. Whether I can do it in 12 minutes, we'll see. So this is the question of whether the nature of the costs incurred in respect of a dispensation application fall within the ambit of paragraph 9 at all. And the Upper Tribunal dealt with this in its decision at paragraph 103 onwards and essentially concluded that the words used in paragraph 9 are expressed in very wide language, and accordingly, because the landlord has a liability in respect of the relevant defects and incurred the costs of the dispensation application as a result of that, the costs were caught. So it's just a very wide reading. And the nub of the reasoning is at paragraphs 113 to 115. I've got, in essence, 2 points on this. The first is that the whole focus of paragraph 9 is upon the liability of those who are responsible for relevant defects, not upon the liability of the leaseholders themselves. As part of that, say, well, leaseholders are the only party with a liability potentially an issue in a dispensation application. And I'll expand on that in a moment. And that's where it says in paragraph 9, where it refers to any person, I say that any person can't include the service charge payer themselves. My second point is that a dispensation application under Section 20ZA by its very nature does not relate to the liability or potential liability of any person incurred as a result of a defect. So it's just not within scope. And that's because its focus is upon whether or not the statutory consultation requirements can be bypassed. It's not upon liability in any sense. I accept, I think I have to, that the judge's approach was at least a logical one to follow, and as a matter of straight language, he reached a conclusion that we can all understand. But that doesn't mean as a matter of law it was correct, and he recognised that in giving permission to appeal, hence it comes before you to consider. And really why I say he got it wrong is because, firstly, he didn't fully consider the intended purpose of paragraph 9, or at least he didn't accept the intended purpose of paragraph 9. And secondly, that he was wrong to conclude that the costs of a dispensation application relates to the liability of any person. So effectively, I say he read relates to in too wide a sense. I'm also going to simply reserve my position, as I suspect the respondents will, as to whether or not legal costs incurred in a dispensation application might instead be caught by the other paragraphs in Schedule 8 on the basis they're part of the cost of the works. That's an undecided point. It possibly arises in another case that's going before the Upper Tribunal in July. The question for this appeal is whether it's covered by paragraph 9. Distilled down, really, I say the Upper Tribunal has read the words relating to in too wide a sense. Yes, I accept, of course I do. In the broadest of senses, there is a causal link between a relevant defect, the fact a landlord must address it, and the need to consult. The point is that in a dispensation application, the legal costs that relate to the dispensation application do not in any real sense relate to a liability. So what I say is if we look at paragraph 9(1) and the words used, no service charge is payable, just pausing there, we have to read that as no service charge is payable by a tenant, because who else would be paying it? Under a qualifying lease in respect of legal or other professional services, and then I say relating to should be read in the sense of concerning, in respect of legal or other professional services concerning the liability of any person. If I say that any person can't be the tenant that is being protected, that wouldn't be a logical construction. Incurred as a result of a relevant defect. And that's the nub of it. One way of reading it is expropriatory and the other is less so. My Lords, I address this, or at least my submissions on this are summarised in the skeleton argument at paragraphs 27 to 32. I'm not going to run through all of them in detail because you have them. I do accept that the words relating to are widely drawn, but we've got to turn back to what's the purpose of the statutory scheme. There is something in the explanatory notes on it. I've already said, I say the explanatory notes shouldn't be given any weight, but it's at the core authorities page 404. They possibly help me on this. I'm not going to take you to them because, as I say, you shouldn't be having regard to them. But the judge's construction, if it's right, requires two things. It requires that the person whose liability is in question is the tenant, who is also the protected party. I say that's not an obvious construction.
Does it depend on it being the tenant?
We have to think about what's the nature of a dispensation application. So a dispensation application is an application to Section 20ZA for a determination that a landlord doesn't have to comply with the consultation requirements. That's not a liability in any logical sense. If you don't get dispensation, the effect is the liability of the tenant is limited to £250 in respect to some works. So if there's any liability, I say the liability is the tenant's.
But I mean, I think what I was immediately querying, which probably shows I've misremembered what the Upper Tribunal decided, is whether the Upper Tribunal said it had to be a liability of the tenant. I thought they approached it on a wider basis.
The Upper Tribunal said that the liability was the landlord's
Yes.
to remediate.
Yes.
And I say the legal services that were incurred here were costs paid to a solicitor to make a dispensation application. Those costs don't concern the liability of anyone. Those relate to a landlord seeking to be relieved from the need to comply with the statutory requirements. So what the judge has done is read relates to in the sense of are in some way associated with, arise out of, and I say that's not what it means. What it means is concerning. Have you instructed solicitors in respect of a claim against a developer to repay the costs of remediating a building because they're liable for it? Is different from instructing solicitors to make a dispensation application.
So just to be clear, on your case, does it really matter whether the liability of any person has to be the liability of the tenant or the liability of the landlord? Your real focus is on relating to, or am I misunderstanding?
I'm arguing both.
Yes, I see.
and I'd take either. A dispensation application is about protecting leaseholders from landlords incurring unnecessary costs. That's why you consult them. If it's going to be a long-term contract or a big set of works, the starting point is you should send a notice of intention. I'm going to do these works. Please let me know your views. If you want to nominate a contractor, please do so. They get in the quotes. They present the quotes. They have regard to the observations. That's the focus of it. The ramifications of not going through that process are a limitation on liability. Beyond that, there is no determination about the cost of the works, whether the works are even in principle payable. Every dispensation decision from the tribunal always makes clear, usually in bold writing, none of this changes your ability to challenge the costs of these works. This is not about how much the works cost, it's about whether a process should be followed.
Perhaps this doesn't depend just on the words relating to. That's an expression which can have a range of meanings, and you're saying concerning. Another translation is having to do with in some of the authorities. But it's not just that, because when you read on, it's got to be, it need only be something incurred as a result of a relevant So here there is a liability to consult, and that there is a causal connection between that and the relevant defect.
Well, I think the difference between us on that would be, I would say that it's not a liability to consult, it might be a statutory obligation. It's a liability there is being used in a sort of stricter.
Well, you have to read that strictly as well. You have to read that as being an obligation to make some sort of monetary payment or to perform a contractual obligation. Yeah. But the consultation requirement is a liability, isn't it?
Well, I'd say it's not a liability in the sense intended there. We've got to think about what are the policy reasons behind this? What's the statutory intent? And why are people bringing dispensation applications? People bring dispensation applications in these building safety cases because they have to be able to contract quickly. There's a huge shortage of contractors in the market. It's difficult to get competing quotes. The Building Safety Fund requires you, once funding is agreed, to get on and do it. You've got to be able to jump on it. And also a lot of time people want to do what's called a design and build contract, where you appoint a contractor, they take responsibility for the design, given the background and everything we know from the inquiry. That's an important feature. So they free up the landlord to get on and remediate. One of the core purposes, going back to where we started this morning, one of the core purposes is to make sure buildings get remediated. Why would Parliament have intended to do anything that stands in the way of that or slows things down? And that's the effect. If paragraph 9 catches a dispensation application, that is the practical effect in my submission. So it simply doesn't accord with policy. And you have an even bigger difficulty, going back to the example earlier of resident management companies and RTM companies. They've got to do this as well. How are they going to fund the costs of a dispensation application? They have to do it because otherwise they can't recover the costs from people with a non-qualifying lease. This is an ongoing problem. This isn't a retrospectivity issue. This is for the future. If dispensation applications are within the scope of paragraph 9, that is standing in the way of the policy of ensuring buildings are getting remediated because it's slowing things down. It's making it more difficult to get on with it. Well, I'm very conscious of the time.
So that's it. That's really your case on ground one.
Yes.
Yes. So Mr. Birdling.
But I haven't taken you in detail to everything in the skirting argument. So if I can ask you to read it.
Yes.
But I think you have the nub of the construction point. It's a shorter point.
Yes. In which case, 2 o'clock.
All right.